Okay. Okay, so this is the first time that we're running this and recording it, so bear with. Um, my name's Chantal Cross from Crosscheck Consultancy Limited, and I'm here with Jackie Thompson from Creative HR Services, and this session is being recorded. Today, we are going to run through all the changes that are going on with employment law, specifically the Employment Rights Act, bill, soon to become act. And we had some changes literally last week, which we've updated. So hopefully by the end of today, by the end of this session, you'll come out with a really clear idea about what's changing and when, and you'll be able to prioritize because how do you eat an elephant a bite at a time, as it were? So let's just talk through why we're doing this today. We actually really wanted to help organizations ensure that they're not making these five mistakes in a nutshell. There are these are the most common mistakes that we see our clients making, which really does increase the time and cost and stress of resolving HR issues. So in our experience, most clients deal with HR issues after the event. It's very reactive. But the problem is the level of risk hugely escalates if you only act when things get a bit tricky. And there's so many things you can do and put in place to make your life so much easier. And we get it. We get it. Everything's sort of on fire. You've got to prioritize whatever and whoever is shouting the loudest. But today's session is very much focused on the proactive action you can take ahead to stay ahead. I mean, particularly in the case of sexual harassment, the risk is huge and it's quite a wide duty because it's the law now. And we'll go into a bit more detail a bit later on. And with small businesses in particular, you have obviously competing priorities like marketing, HR, payroll, sales, and the laws change just so quickly. But you can take these small steps to minimize your risk and move ahead. So I'm going to hand over to Jackie first now.
So, hello everybody. My name is Jackie Thompson. I run Creative HR Services. I've been working in HR for about 25 years and particularly always focused working with SMEs. So, my business model is about being proactive and not reactive. So, everything you're going to be learning today is going to be looking at how you can be more proactive with these new employment laws coming in. The other thing I would say is year on year, employment tribunal claims are rising. And with the Employment Rights Bill, there will be more claims. So, to give you an example, in the last year, there's been a 36% increase in employment tribunal claims. And actually, disability claims have risen more than 40%, and you don't need any service for them, particularly around mental health, actually. And I always say to my clients, the cost to defend a tribunal is 50,000 plus, actually. And that's even if you win. So even if you've got a really strong case, the paperwork, the time, the admin, and the stress it costs. And I'll hand you over to Chantal, who'll tell you a bit more about her business.
So yes, I've been going about a year and a half. I got into HR about 20 years plus VAT ago. And I got into HR really to help people to make sure that people were being treated well at work. And when I went self-employed about a year and a half ago, this new law was coming in to prevent sexual harassment. And I really sort of gravitated towards it. So whilst I do have a wide range of skills, that particular work is what I love to do.
Okay, so today's session, as we said, we're going to go through the employment rights. It's the bill at the moment, but it will be the act once it comes through. We're going to be talking about what's changing, when it's changing. So we'll give you the dates of what they're telling us now and how you can prioritize, what to prioritize and when. So the Employment Rights Bill is the biggest shake-up of worker rights in a generation, and it's set to bring major changes to UK employment law that will affect every business, no matter how small you are. So even if you've got one employee, it will affect you. It's at its final stage of the journey through Parliament, which is often called ping pong. So it's being debated at the moment and absolutely hot off the press. You may have seen in the news last week on Thursday. Day one rights is something that was being debated through Parliament, which is a good thing because it was going to be hugely impactful. They've now changed day one rights, so it's not day one anymore. It's going to be 6 months. But that qualifying period, and I'm going to talk to you about that in a second because it's still a very short period. And they're still debating some of the changes. So the guaranteed hours for 0 hours workers, they're still debating. So there's still a few more things to go through that ping pong stage. But it's expected to receive royal assent very soon, and then it will become law. So what we're going through today is the current state of affairs. As we know, they're still slightly changeable, and we're going to be doing these webinars every month to keep you right up to date. But one thing's for clear, significant change is coming. So let's run through them. And there will be an opportunity for any questions at the end. In April 26, so that is just round the corner, we've got parental and paternity leave from day one. I don't think these are a big deal, so I would say the impact is low here because it's bringing it in line with other statutory leave. How you can prepare. So you'll need to update your policies when the day one becomes effective, and also train your managers. Make sure your policies are up to date. Make sure your managers know that those changes have come in. Then we've got statutory sick pay changes. So again, from April 26, it'll be day one. So at the moment, we've got this waiting period. And the lower earnings level will be removed. So everybody will qualify for some element of statutory sick pay. How can you prepare? Make sure your payroll's ready for those changes to come in effect. So speak to your payroll provider, or if you do it in-house, make sure your systems are ready. And check your absence policies because there is the potential that absence might increase a little bit if people are getting that from day one. And you want to make sure your absence policy talks about how you'll treat people fairly and consistently. And then we've got the Protective Award for a failure to consult on redundancies, which is why if you're speaking to a HR person when you're dealing with redundancies, we're always saying it's important to consult. What they're doing is they're doubling the award. So at the moment, it's quite significant anyway. It's 90 days. They're going to increase that to 180 days.
Is that per person?
Per person,
Yeah.
which could be significant. Think about people's pay. That's a significant compensation award. So to prepare for this, review your policies now, your redundancy policy. If you don't have a redundancy policy and you're going to be doing any redundancies, do make sure you speak to a HR professional to make sure you get that correct. And then train your managers to make sure they understand those consultation duties. Then moving forward to October 26, I know there's a lot to be prepared for. We've got the tribunal claim limit increasing. So it's going to be increasing from 3 months now to 6 months. And it just means employees have got the opportunity to raise a claim for a longer period of time. Really, just to prepare for this, just be aware that that's the case because there will be more cases. It'll just prompt people and give them more time to put a case in if they want to.
It's just even more reason, I think, to have really robust HR and systems and policies and communication with your staff in place, really.
Absolutely.
Yeah.
And then we've got fire and rehire. So a lot of people, that's a bit of a technical term. What that really means is about changing contracts. So your employment contract, a fundamental piece in your business. And we see this as having a high impact. Hopefully that will get debated a little bit more because from a HR perspective, we think this will be really, really difficult for businesses to manage. To give you a couple of examples, and the only exception to this is if you're in serious and financial difficulty, which is going to be a very high bar to meet, and you'll have to evidence that. But say, for example, you want to update your contract because you want to put new clauses in. You won't be able to do it unless you get the employee's agreement. You won't be able to force those changes. Say you've got employees on various different terms and conditions, and you want to, which people often do now, put them into one. You won't be able to do it unless you get an employee agreement. And even harder, so say, for example, you've got a cleaning company and the shifts are 8 till 2 at the moment, and the client comes in and says, no, I don't want 8 to 2 anymore. I want 10 to 4. You can't change those contracts again without employee agreement, which makes it really, really hard to run your business.
I really do feel for businesses, and I'm glad that these things are getting, more debated because it does sound very unrealistic.
Absolutely. So it's one we're hoping there'll still be changes to, but at the current stage, this is where it's at. So how to prepare? We're not saying to change anything for now because, hopefully there will be changes, but just review and update your contracts in the near future. When we know that this is solid, which we'll know in once this is passed, it will be confirmed. Then start looking at your contracts and variation clauses. So the advice is get as many variation clauses as you can in there. It won't necessarily give you 100% protection, but it just helps. Avoid putting non-contractual benefits in your contract. So I see this quite a lot when I review people's contracts. They have things like that says, well, we do sick pay, but it's not contractual, or we offer a bonus, but it's not contractual. If it's non-contractual, don't put it in your contract in the future, because remembering, if you can't change it, you then get yourself in a bit of a pickle. So in the future, take anything that's not contractual and put it into a policy. Make it clear in those policies it's non-contractual, and then you can revise and update them when you need to. Tipping rules. So if you're in a hospitality or service industry, the changes are you must consult your staff on tipping policies and review them every 3 years. So obviously you've got to make sure you've got that tipping policy in the first place. But then you need to think about how are you going to consult with employees to meet that requirement. And then October 26th, we're having more changes to that duty that Chantel said earlier on about preventing sexual harassment, increased duties, all reasonable steps. Third-party harassment, I'm going to leave that all to Chantel because that's her area of expertise, and she's going to cover that in a second for you in a lot of detail. And then finally, 2027 changes. So we talked about unfair dismissal day one. That has now changed. Hot off the press, it's going to be 6 months qualifying period. However, I think is still absolutely significant. Please don't say, oh, that's great, because all the recommendations that we would still have still exist. You're going to have 6 months to review somebody before they get unfair dismissal rights. So that probationary period is going to be absolutely critical. You've got to make sure you won't just be having an end of 6 month probation anymore, because at that point they'll have employment rights and could claim unfair dismissal. You're going to have to make sure you've got a different probationary review process, and that is really solid. We would also say train your managers now. Now, this is one thing that I think you can absolutely do now, because don't wait. We've already been told this is coming now. It's going to be 6 months. So start looking at your recruitment processes. Are they solid enough? Do you do proper interview questions? Have you got a job description? Have you got interview tasks? How are you making sure the people that you employ are really the strongest candidates in the first place? So I think a lot of work you can do on your recruitment process. Then you've got them onboarded. So again, how are you going to onboard them really quickly? Because now you've got only 6 months to assess them. Then your probationary period, you can't just wait and have a 6 month review. By that time, you've lost the ship sailed. You're going to have regular interim reviews and document them. And even after the 6 months, when they've got employment rights, don't forget they can then take you to tribunal from 6 months. Performance management is going to have to be much more locked down, much more detailed, much more documented. As we always say, Chantal, don't we? If it's not written down, it didn't happen in a tribunal. That's how tribunals operate. And then we've got guaranteed hours for 0 hour workers. Now, this is still being debated in Parliament. It's one of the ones they're not happy about, and rightly so, because a lot of industries have to work on 0 hours and they need them. And what this is going to do is give a right to a new or varied contract which reflects the number of hours the employee has worked during the previous reference period. They always make these things sound very complicated, but really, if a person works, 16 hours a week regularly, that's what they're saying, and they do it over a consistent period of time, they should be given a contract of that, which will obviously make a massive difference to employers' flexibility when you're dealing with seasonal work, for example. So this is so complex, even HR people or lawyers haven't got their head around it. We will continue to update people as they come in, as the changes come in, but we would say conduct an audit of your 0 hour workers now, so you know how many people is this going to be involved. You don't have to do anything else for now, but we'd say at least be aware.
Yeah, that's a good idea.
How much of your workforce is this? And then obviously think about your budgets and what kind of impact this could have if it does come in.
Well, and also, I guess, thinking about future plans and how, how their workers or employees could be impacted.
Absolutely. It's really now time to just think and look ahead.
Mm.
So flexible working, it's not the change that they said they were going to bring in, which again is good because they were kind of, the newspapers were saying everybody's going to have rights to stay at home and work from home, etc. That's not what they brought in. They brought two main changes in, which will come in 2027. First of all, it must be reasonable for the employer to refuse the request. So you're going to get challenged more on any refusals on flexible working, and the employer needs to explain why it's unreasonable to agree to it. Now, Chantal, you and I would have said this is part of best practice to do now anyway, but come 2027, this is going to be law, so you will have to follow that process. So again, once these come in, you'll have to update your flexible working policy and your template decision letters and train your managers to understand that that is the new process. Bereavement leave is going to be again in 2027. It's going to be extended to a loved one, but they haven't defined that yet. Likely to be about a week and probably unpaid. So when it does come in, you will need a bereavement policy if you haven't already got one. Most people do, but you'll need to update it to reflect this. Train your line managers so they're aware of it as well. And then we've got reasonable notice for shifts. So if you've got, again, employees who work 0 hours or agency staff, they will have the right to reasonable notice of shift changes or cancellations. So again, to prepare, we would say audit how shifts are planned and communicated. So again, just do an audit. How lastminute.com are we with these? Start providing more notice now where possible. Try and get into that best practice way of working, and then wait for more information because we will let you know as that changes. And then the right for payment for shifts that are cancelled or moved at short notice. So if you don't give enough notice and the notice is yet to be defined, you would end up having to pay that shift. So again, you want to avoid unnecessary cancellations, and we'll provide more information once that comes out. And finally on my list, we have got menopause support plans.
So much,
I
isn't
know,
there?
I know. So a lot to take in, I do understand. Menopause support plans is really for larger employers, so 250 plus employees. And they're saying at the moment they may need to publish a menopause support plan. So part of this will be making sure you have a menopause policy. But I would say, regardless of your size, have a menopause policy. And the reason for that is we're actually seeing some cases now coming through for disability discrimination in relation to menopause.
Well, yeah, and given that only 1 in 10 women apparently won't actually experience any symptoms, it's going to affect an awful lot of people as we are an aging population.
Absolutely. So have the menopause policy regardless of your size, but bigger companies, you will need to do more, and you will need to have a proper, and we suspect the action plan will need to be training as well. So it won't just be enough to have a policy. If you're a bigger company, they will want you to have a more wider plan, training, documentation, support systems, etc. So just a reminder, the proposals are what they are currently. As I say, we just had that update to the day one, and we will continue to update you as the changes come in. So I'm going to now hand you over to Chantel, who's going to go through the Worker Protection Act for you in a bit more detail.
Okay, before I kick off, in the chat, could you just put how confident you are with the prevention of sexual harassment at work? Just generally, do you know what to do? So put a 1 if we have a scale of 1 to 5. So 1 is don't have a clue, and 5 is yeah, I know everything, I'm awesome. Could you just pop in the chat just where your confidence levels are? Oh, 4.5. Oh, Mary, that doesn't surprise you. I know you're very experienced. And Chloe, 4, 2 to 3. So we've got quite a wide range actually of confidence levels. Oh, 3.5. So lots of people not wanting to commit to a whole number. Brilliant. Okay, well, thank you so much for letting me know. So, as you'll know, the Worker Protection Act came in, it was Worker Protection Act 2023, and there was quite a lot of discussion about these reasonable steps. So I think originally it was going to be all reasonable steps. So employers need to take all reasonable steps to prevent sexual harassment in the workplace. But then they backtracked that to just reasonable steps. And we'll go into a bit more detail a bit later on as to what that actually means. But in a nutshell, what's changed is that it's become law, and it came into law last October. Sorry, the October before 2024. And this mandates that every employer must take reasonable proactive steps to prevent sexual harassment in the workplace. The future changes that will be coming into effect is in October 2026. The bar is getting higher, and it will become all reasonable steps. We'll talk about that later. But the other thing is that, why on earth are we actually needing to do this? I mean, there is so much evidence that it's a huge problem at work. I mean, you've only got to turn on the news to see the latest Greg Wallace Harrods NHS debacle. It seems that no industry is immune to this. I mean, the Met Police, I think only about a month ago, they had, in the wake of Sarah Everard murder, they were very much under fire for institutionalized sexism and racism. And unfortunately, it looks as though that behaviour has just gone underground. It hasn't been and this is the problem with this kind of thing, which is why it needs to be a proactive duty, because once it takes root in an organisation, it's so difficult to to backtrack. Gallup have found that more than 1 in 5 employed people worldwide, so that's 23%, have experienced one or more forms of violence or harassment at work in their lives. So that was a more recent global study. So quite apart from anything else, it is the right thing to do morally, but it's also really good for your business. Organisations with a high level of engagement report 22% higher productivity. And it makes sense, doesn't it? If you feel safe and valued in your workplace, then you're going to want to, have less sickness and be more productive, and you're going to enjoy work a lot more. And I've already mentioned, obviously, it's the law. The key implications for this is that I don't think people understand how wide the duty is. Someone could just overhear someone else or see inappropriate behaviour, even when it's not even directed at them, and that could give rise to a claim. People also don't have to complain for there to be a risk. And similarly, someone could join in with the banter. Very often people do, to protect themselves from further harassment. But they could still, submit a claim. They could change their mind overnight. So what's good one day could not be appropriate the following day. It's also a proactive duty. So it's no good closing the door after the horse has bolted, as it were. You need to be thinking about where the risks are for your employees and your workers, because that's the other element to this. So rather than just responding after incidents occur, and at least 50% of the organisations that I work with have had an incident and then call me in to help them.
Well, that's huge.
I know.
That's huge. And actually, on that risk level, we've got Christmas parties coming up.
Oh God,
I just
yeah.
thought I'd mention that one because it's something that we get a lot of stories from a HR perspective, and these are real life cases that come from them. Is there any advice you'd have on that particular risk factor?
Yes, well, actually, I have drafted some communication that you can send out to your employees. So my immediate quick win really is to send out communication about standards of behaviour, do a risk assessment beforehand, particularly if alcohol's going to be there. And yeah, I think those are sort of my two top tips off the top of my head. I mean, obviously, with all of this as well, there comes a certain amount of risk. Non-compliance can obviously lead to employment tribunal claims and potential compensation increases of up to 25% if the Equality and Human Rights Commission take an interest in you. In addition, tribunals will also take into account what would be reasonable for your organisation or business. However, they won't be taking that into account when they're issuing any sanctions, particularly financial sanctions. And those sanctions could be actually unlimited in terms of finance, because it's viewed as discrimination if it's connected to a protected characteristic. It's also a cultural piece of work. It's not a tick box exercise. And whilst I think it's amazing to implement, you know, to cover everyone off with some recorded training, I think that's better than nothing. You really need to tailor it for your organisation, and it needs to be a living document, a living piece of work that is executed at least once a year. So, and the last implication, which I haven't written here, is obviously this extends to third parties. So, for example, if you're in the hospitality sector, that has greater implications, and so it's thinking about how you're going to get that messaging across to the third parties. So let's go through what this reasonable steps mean. So in true employment law fashion, they've got this really vague term, and what is reasonable is going to be different depending on your organisation, the kind of work you do, the industry you're in, the hours you work, the type of people you've got in the business, all sorts. So one size does not fit all. However, there is some guidance out there. The Equality and Human Rights Commission have the technical guidance. So it's about 83 pages long, but it is fairly plain language within. It's not sort of really technical language, so it's fairly easy to understand. It's just long. It's really long. So really, you need to take sort of more of a holistic, wider view on the risk to your organisation. Obviously, you need to outline what your approach is to this risk, and what behaviour is inappropriate and how you'll deal with it. It's also about communicating and engaging with employees. How are you going to get that input back from your employees and your workers as well? You can do this through one-to-one staff surveys. I mean, the thing is that attitudes are changing whether you like it or not, and there's a perfect melting pot within your organisation right now of you know, the world of work looked very different in the 1970s when some people started work to now. And Gen Zs are coming into the workplace, who have been brought up within the Me Too movement and have higher standards and are more likely to find and complain about inappropriate behaviour. That also brings me on to regular training. There's employment law, a case law that have indicated that you really need to do this training at least once a year, and it needs to be tailored. But also you need to look at the systems and processes that you've got and the reporting systems. How are people going to report? There's also so much evidence to suggest that under-reporting, literally every report I see is well over 50%. So the smallest percentage of underreporting I've seen is about 53%. The largest is about 79% of underreporting of sexual harassment within the workplace. So it's about removing those barriers so building that trust about how you're going to deal with it, but also I would highly recommend that you implement an anonymous confidential reporting procedure. If you're stood up in front of an employment judge, that's a really good way of indicating that you have taken reasonable steps to prevent sexual harassment. And I have a partner I can recommend. If you're interested, just let me know. So what is this difference between reasonable steps and all reasonable steps? So currently you can't actually sue for third party, but that is coming. But the Equality and Human Rights Commission do have the power to intervene if the employer fails to take specific steps to prevent third party harassment. Obviously, in October 26, this is changing to all reasonable steps. So, and there is a big change in that the employer can be sued for third party harassment. Reasonable steps means that the employer must take proactive, proportionate action to prevent sexual harassment. So doing what a prudent employer of their size, resources and risk profile would do to minimise the likelihood of harm. In contrast, all reasonable steps is a higher legal threshold, and it requires the employer to demonstrate they have taken every step that it would be reasonable to take in the circumstances, not merely some or most. The difference is subtle, but really important. There was one other thing I was going to say, and I can't remember what it was now, but I'm sure it'll come to me. So let me just bring this to life for you a little bit more. So let me talk about a few cases. The first one is Moonstar versus Five Ways Express Transport. This is where a female worker saw male colleagues downloading and viewing pornography at work. Now, this was not circulated to her. They didn't talk to her about it. They didn't show her or forward it on, but she was aware of it. But at the time, she didn't complain because she was worried about losing her job. And it was viewed that this created a hostile environment. The behaviour was unwanted and it was of a sexual nature. So she won her case. In Hunter v. Liddell, the lady Hunter was awarded £50,000 after she requested verbally to move stores to one with a female manager because her eventual formal complaint wasn't taken seriously after she rejected the advances of her manager and another male colleague, as well as other claims like equal pay. In the last one that I'm going to talk about, Beanie versus Highways England, this case demonstrates that not only is the organisation at risk, but that individual people employed by the organisation can also have to defend tribunal claims against them individually. Here, Beanie was a trainee and was subjected to unwanted advances again from a manager, which she made clear she was not interested. And when she said she would report his behaviour to HR, he replied that he could have her killed and buried for £4,000. She was awarded £74,000. And there are so many cases to think about. There's honestly no shortage of material. So just briefly, both myself and Jackie are super experienced, and it doesn't cost you anything just to pop into LinkedIn, drop us a message, and we're happy to chat through anything that you might be bothering you right now. And we also offer training. I offer like an anti-harassment toolkit, and incorporated in that is all the tailored training.
So one of the other new products that I've launched recently is the Creative HR Compliance Club. Obviously, all my clients will get all of this information as part of their up-to-date service, but this is a package you can buy separately on its own if you don't have any other services from me. And HR Compliance Club, what it does is it gives you 20 policies to meet all current laws. And what you'll effectively be on from there on in is an update service. So every time these laws come in, I'll be sending you the new policies. So you don't have to worry about compliance. You don't have to worry, oh gosh, when was that date? What law was coming in on what date? What policy do I need now? So, like I say, 20 policies to begin with. You will get new policies as and when they come out, and that's all set up. It's £35 a month plus VAT, and it means you can be absolutely certain you're up to date and fully compliant with all the policies you need to meet these current laws.
So just a few quotes about some of the training that I've done, which is part of this package. I really do all the hard thinking for you. So I've thought round all of the angles, been through that technical guidance more times than I can remember. And I don't just stand in front of you and talk about it, make it really super interactive, and I've also gamified the training, so it's quite good fun. I really love doing it.
And some quotes there from some of the clients that have worked with me in the past. I believe there's a couple of clients on the call today. But with Creative HR, very much providing the best service is really, really important to us at an affordable cost.
So just before you go on, there is an offer at the end, so please do stay on. So this is just the checklist now that you're gonna take them through.
Absolutely. So what should you do now? Contracts. You can start looking at your contracts in advance, because if you think about the new laws coming in, you need to work backwards from that new law. Sounds like a long time away, October 26th, but when you take in how big is your company, how long do you need to consult for, it's going to get time to go back and forth and get your contract right. I would say start looking at your contracts by early 26 so that you're well ahead of this. And also you'll have to consult and make those changes before this new law comes in. Now, start reviewing your recruitment and induction processes and probationary processes. I wouldn't wait any longer. Also start training your managers. It's really, really important to train your managers. It's the biggest thing that I could really say to businesses. If you want to reduce your risk going forward with all these employment laws, your managers are the key gateholders of everything. So we're going to be running manager training sessions.
Do you know what percentage of managers, according to one study, indicated actually instigated harassment?
Oh, well, the managers instigated it.
Yeah,
I don't know how many.
53%.
Oh,
So it's actually a really good point that you're making to
wow.
actually tackle managers,
Start with
because
your managers first. It's your culture. It's a really
yeah,
important piece.
yeah.
So lots of things you can start doing without having to change your policies yet. Wait until the new laws come in to change your policies, or subscribe to the Creative HR Compliance Club and we'll do it all for you. And look at, even after probation, you need to look at how you're managing performance in the business. So your annual appraisals are done and dead and buried. We never recommend them anyway. You need more regular processes in place, and it has to be documented. So no longer write your probation reviews on your notepad that you're not going to be able to find if you get a tribunal
And
claim.
remember, if it's not documented,
It didn't happen.
yeah.
According to, and that's it will be how tribunals will look at things. Systems and communication, so we can recommend a really, really affordable HR system. So if you've only got a few employees, it's still cheaper to have a HR system, because that will record your probationary, it will automatically remind you if you miss these probation timescales, if you miss that 6 months, the person's gone into employment rights. You can't then say 6 months in a day, oh, I've got a problem with their performance, or you're going to have a risk of a tribunal claim. So you've really got to keep those systems and documented, and it's so affordable, this system. I mean, I think it starts at something like £20 a month.
Yeah.
And you can automate things and make things easier anyway. So we would definitely say don't do spreadsheets.
Well, we've gone out to the market. Any issue that you've got problems with, whether it's an OH provider or doing staff surveys or whatever the issue is, we'll have done the research. So
Absolutely. And Chantel, what for sexual harassment, what should they be doing?
So in terms of sexual harassment, you absolutely must do your risk assessment, and that will drive everything else. So your risk assessment will look at power imbalances, where people are doing lone working, where they're doing, where alcohol might be present, and just and then all the actions should flow straight from there. But obviously get your policy in place, do your training and do your risk assessment, and I'm more than happy to have a chat.
Great.
So thank you so much for coming. Our next webinar is not the 1st of December 2026. I was waiting for that creeping death to come with that mistake. It's actually the 12th of January, I believe, 2026. So we will be advertising this and we'll send it out. But the first 10 people that get in touch with myself or Jackie, we will do you a free little where you're at review. So in the meantime, please do find us on LinkedIn. Don't be a stranger. And I hope you have the most amazing Christmas break when it comes.
Thank you, everybody. Thank you very much for joining us today. And if you do get any questions, feel free to reach out to
We'll
us.
stay on. So talk to us. Please do give us any questions that you've got. Oh, Edward, you are so, so welcome. Thank you, Ivana. Thank you for attending. Thank you, Polly.
Thank you.
Any questions? Happy to help. Thanks, Mary. Lovely to see you. Thanks, Chloe. Right then, I don't think we've got any questions, have we?
No, I think that's all good. And thank you, everybody, for joining again.
All right, bye.
Bye.